Welcome to DocPro's channel. DocPro has all the documents you need at your fingertips. This video will introduce the types of involuntary termination you should be aware of to ensure that there is no breach of law. Involuntary termination occurs when an employer lays off, dismisses, or fires an employee, or when the business decides to sever the employment relationship. If the employee has been constructively dismissed and forced to resign, this may also be involuntary termination. This is as opposed to voluntary termination, where an employee chooses to leave, retire, or take up a voluntary layoff offer. How an employee is dismissed will affect the compensation and benefits they receive post-employment. Involuntary termination often comes with additional benefits, and will usually be accompanied by a severance agreement, which typically provides the employee with a large sum of cash to ensure that the company will not be sued. On the other hand, if a person voluntarily terminates their contract, it is likely they will not receive unemployment benefits. This is because people who voluntarily terminate likely already have other arrangements lined up. Different types of involuntary termination. An employer can involuntarily terminate an employment contract with cause by firing an employee, or without cause by laying off an employee. Employees can also involuntarily terminate their contract if they are constructively dismissed or forced to resign. Involuntary termination with cause happens if an employer fires an employee for reasons of performance or misconduct. This may be when the employee has violated company policy, failed to perform their duties, displayed consistently poor behavior or attitude, or acted in an unethical manner, violating company policy. Depending on the jurisdiction, a company may dismiss an employee who has committed gross misconduct without warning. Termination with cause is usually used as a measure of last resort. The employee should have been warned that they would be dismissed if their behavior continued. However, immediate termination is possible if the policy violation is very severe. Involuntary termination without cause happens when an employer lays off an employee, typically due to changing market conditions or business decisions that require the dismissal of workers. Organizations may downsize or restructure to reduce operating costs and increase productivity, meaning that some employees will become redundant. Finally, constructive dismissal is a legal term referring to where an employee is forced to resign due to a hostile working environment created by the employer. This differs from firing or resignation because the employee has no choice but to leave due to such working conditions. Hostile work conditions can include sexual discrimination, harassment, unreasonably long working hours, or bad treatment. Procedures for involuntary termination. Every employer should have a formal employee handbook detailing disciplinary policies. This should be reviewed to determine policy violations and proper procedures for firing an employee. Employers should also investigate grounds for termination by collecting evidence to substantiate their case with compelling reasons. Notably, there may also be some circumstances when firing an employee becomes illegal. For example, when establishing a case for firing someone, it should not be based on a particular characteristic like age, religion, sexual orientation, or disability. Employers should also sit down with the employee and explain why they're choosing to let them go. A termination notice should also be given in writing, such that both employer and employee are aware of the circumstances of termination. Finally, employers should also make sure that the layoff is necessary when laying off an employee. This could be due to compelling reasons like significant organizational changes. For example, they should look at whether redundancy can be avoided by filling vacancies elsewhere in the business with existing employees. Once again, in selecting who should be laid off, these should also be based on criteria like performance, knowledge, seniority, and skills, rather than characteristics such as race, age, or disability. Depending on the jurisdiction, Employers may also have to give advance notice or offer severance pay to their laid-off employees. If you want to find out more about involuntary termination in different jurisdictions, check out the link to our full blog in the description, which also has customizable templates for your use. Thank you for watching, and feel free to like and subscribe if you found this video helpful.